Welcome to the Eversheds Sutherland Inquiries and Inquests podcast. I'm Catherine Henney, a legal director in the Inquiries and Health and Safety team. Today's episode is titled, Are Prevention of Future Death Reports Fit for Purpose? And I'm joined by David Pojur, Barrister at Lincoln House Chambers and Assistant Coroner for North Wales. When not sitting as a coroner, David acts for interested persons as well as for coroners in the role of counsel to the inquest or as part of judicial review proceedings. He often guides serious incident reviews and frequently argues the law relating to prevention of future death reports. In this episode, David and I discuss the statutory purpose of prevention of future death reports, or PFDs as we will call them, the training and guidance given to coroners on when to issue them, and the often posed criticism that PFDs lack teeth, with no sanctions available for those who fail to respond to a PFD. We consider whether the approach of the new Chief Coroner signifies a sea change and whether we will see increased scrutiny of PFDs and those who fail to respond to or act upon them. We hope you enjoy. So, David, can I start by asking you just to explain a little bit behind the statutory purpose of prevention of future death reports, or PFDs as we'll call them in this podcast, when they were introduced and why?
They were introduced quite a while ago. They emanate from Regulation 28 and the Coroners Regulations 2013 and the Coroners and Justice Act 2009. And they are so that there can be an improvement in public well-being and that lessons can be learned. They're not supposed to be punitive, and the coroner doesn't make recommendations. It's supposed to highlight concerns so that they can be noted and, where appropriate, action to be taken.
Okay. And so when we look at what the actual wording is around that duty and when these concerns arise, it's quite a broad duty on my reading. So the wording in Schedule 5 of the Act, it says that it's where the coroner may have where there's anything revealed by the investigation that gives rise to a concern that circumstances creating a risk of other deaths will occur or will continue to exist in the future. That sounds like it's got quite a subjective element to it, and it's also quite broad.
It is, and it's a low threshold as well. And one of the things that you've said there is anything in the investigation, so it doesn't have to be on the inquest. The investigation starts as soon as the coroner receives the body into the jurisdiction, so to speak, and then opens the investigation. From that point on, if there's anything that the coroner has concerns about that will give rise to a potential future death, they are required to make an assessment, which is subjective, as to whether they have any concerns that a future death will occur. And if that concern is satisfied, then the mandatory duty is then engaged and they must issue a prevention of future death report. And so what they've got to do is look as to circumstances which may create a risk of further deaths in the future. Doesn't have to be imminent, can be at any point, but if they've got that concern and they've identified it, they then must issue prevention of future death to anybody who they think has the power to take action and do something to remedy that concern.
And so that can be to any individual, any organisation, can it, that it can be issued to?
It can be absolutely anybody, and it doesn't make recommendations. So the recipient of a report, whether it is an individual, an organisation, a government department, Secretary of State, whomever, it doesn't tell them what to do, but it will highlight what the deficiencies are and that concern ought to be taken. In reality, some of the PFD reports do come quite close to making recommendations, but they can't be framed in such a way as to tell them what to do. And the response has to be given within 56 days, unless there's an application to extend that time period, by the recipient. And the duty on them is quite clear. It's to set out what action they have already taken, what action they intend to take, or that they're going to take no action at all. And as soon as the coroner sends the PFD report, their role is over. They don't get to mark the homework that comes in from the recipient.
And that 56 days runs from the moment that PFD is issued?
It does.
It does. And so just thinking about that, then presumably there could be quite a variation in what a PFD looks like and the amount of detail that it goes into depending upon the particular case in question.
Yes.
Does it require any kind of knowledge from the coroner to sort of know? You say it's not to make a recommendation, but presumably they're trying to look at, in the case of organisations, actions that they think should be taken. How are they able to frame that? Do they invite submissions as to or expert input as to what they think needs to be done to address the concern?
Well, Chief Coroner's Guidance 5 and the new Chief Coroner's Bench book, the Guidance from the Bench, Chapter 16 deals with this. There's got to be an evidential foundation. No coroner ought to be making a frivolous prevention of future death report. And so in order for it to make sense, and of course it's going to be publicised on the Chief Coroner's website, as all PFDs are, the responses are, it's got to stand alone as a document. So it doesn't rehearse the facts, it gets to the point, and the coroner is going to be able to have an insight into what the issues are from the material provided through the investigation or the evidence, and that can include expert reports. But all they've got to do is say, I've got a concern about this, and then it's over to you. What are you going to do about it? So it should make sense within a report, but very often a coroner will say, I want to know what you've got to say about this, or help me with it. So I'd like a statement on PFD from a particular interested person, or I want to hear evidence from a representative, for example, somebody that's written a serious incident review to explain what's been done. And very often the coroner will just say towards the end of an inquest, right, what's the learning on this? What's changed? What needed to change? What are your views? And they might say to themselves, well, I'm satisfied that there has been a change because I thought that there needed to be change and hence no PFD, or I still have concerns. And they don't have to issue a judgment on it. They don't have to invite submissions, because actually the realm of a PFD is entirely ancillary to the inquest itself. It's not the mainspring. And there ought not to be lengthy hearings added on to an inquest because of that. And some coroners, and it varies from jurisdiction to jurisdiction, will say, you're not addressing me on that. It's exclusively a matter for me, and I'll decide and I'll let you know in due course.
And that's interesting, isn't it? Because, and I think it was in the case of Dillon that the High Court acknowledged that very point, is that actually, whilst one coroner's interpretation of the facts is maybe such that they do have a concern that there's a risk of other deaths in the future, another coroner on exactly the same set of facts may take a very different subjective view that actually they don't have a concern and they might not reach the same conclusion. So that sort of, I guess, begs the question of whether there's a consistency point here around approaches of different coroners up and down the country as to when a PFD isn't appropriate or is appropriate. And you say that, they don't have to invite submissions on that. In practice, do you think coroners feel that they have to invite submissions to get that point right because it is so subjective, or do you think they feel, well, look, I've got this judicial discretion and it is a matter for me?
Well, the coroner's wide discretion is recognised within the law sheets and the case law, and so it's they who set the boundaries. And if they feel that they ought to issue a PFD, or conversely that they shouldn't issue a PFD because sufficient action has been taken, then it's a matter for them entirely. The case law on this is really quite scant as well. You've got Dillon from 2022, and in that decision against the coroner for Rutland and North Leicestershire, the High Court said the coroner was entitled to conclude there was no need for action to be taken to issue a prevention of future death because the threshold wasn't met. So the coroner's entitled to say, I've heard and I've seen and I've read, and my concerns are allayed. And so that's why there's such scant case law on it. The reality is that coroners will say, I've got a concern about this. Tell me what you've done. Where's the evidence? What should I look at? Or at the end of an inquest, they'll say, right, you've got 7 days to send some more information to me and I'll let you know. And it is one of those that does vary from not just jurisdiction to jurisdiction, because one has to remember there is not one coroner's court like there is a Crown Court. There are many, many jurisdictions, and within them many coroners. And so while the jurisdiction may have a flavour, each coroner is his own judge. That's been made clear by Lord Justice Laws and the Chief Coroner and the like. And so they'll take their own view. And so the reality is, if you think that your client or those you're representing is exposed and there's a gap and there's an issue there, then temper it with a statement or something explaining the learning so that the coroner understands it, and the earlier the better, because it is extra work for the coroner. If they do have the concerns, they are going to issue a prevention of future death report. But we also know from the preventable deaths tracker, which is relatively new, that some coroners are more prone to issuing PFDs than others.
Yeah, and we'll come on to the stats in a minute, because there are some really interesting statistics around that we'll talk about. But I think as a practitioner, I think you're right in the sense that when we have clients that come to us in these sorts of inquests, I think you do know quite quickly where there might be one. They think, okay, we might be in PFD territory here. We might want to look at helping the coroner on that line if he or she is minded to go down the PFD route. But I think also what we have noticed over the years is that there is this tendency to turn inquests into something other than the summary process that they're there to deal with, to investigate the death, and this widening of scope and this widening of issues to try to bring in perhaps consideration of other things that are not actually properly within the jurisdiction of the inquest. So I think what I'm interested in when it comes specifically to the point of PFD is, how does a coroner judge when a PFD is properly, I guess, in scope or properly there to be dealt with, versus when actually it might be being sought by parties as part of proceedings unrelating to the inquest, so maybe a civil claim or
I think sometimes it's very obvious. You will get a party. I was in a pre-inquest review, and solicitor for one of the parties said, we want all of this paperwork because it's going to help us with the civil claim. And that shouldn't really happen at all, because that's not the function of an inquest. It's not there to establish civil liability or criminal liability either. And so I think that puts everybody on notice that one has to refocus and remind oneself of what the actual purpose is of an inquest. It's to answer those 4 statutory questions: who the deceased was, when, where and how they came by their death, in an Article 2, in what circumstances. But that doesn't mushroom it into a public inquiry. It shouldn't do. And the Court of Appeal in Morahan were very clear about that. It's a relatively summary process and not a public inquiry. And also, coroners don't want their resources being taken up with inquests turning into public inquiries that are going outside of scope. And so when I as counsel receive instructions for an inquest, I look at what's the likely conclusion, what are the options for conclusions, what's the remit for a prevention of future death report amongst any of the interested persons, what should the coroner be looking at. And of course, once you've looked at that, you've got to consider what scope should be. It should not be a particulars of claim or negligence, and it doesn't represent pleadings. And this is where people go wrong. They think it is an adversarial system, and the best way to get what they want is to treat it like a criminal court or a civil trial. It doesn't fit. And the feedback from coroners and other court users is that it makes the inquest quite disjointed. And that's why scope, which is not legally defined, is nothing more than topics. And going into too much detail in relation to scope can be too restrictive. But then leaving it too broad and woolly is not going to help anybody. And it's moving as well. So it is one of those things where it's good for everybody to know what we're looking at and identify it, but it's not set in stone. One does have to follow the evidence. And whereas at the beginning of a case you might think there's no PFD issues here, you don't know what a witness is going to say or what an expert is going to throw up when they're questioned, not cross-examined, because that shouldn't happen in an inquest. But that's why it's a moving feast. And so although PFD is often left till the end, some coroners will turn around and say, well, I'm not thinking about that right now. I've seen submissions from some interested persons at the first PIR, and they set out what their concerns are and why a PFD should be made. It's not very helpful in setting scope because the coroner will say, that's not what I'm interested in at the moment, and they'll return to it later on. But the best thing to do is look at where the gaps are and get scope appropriately set moving forward.
I think it comes to the point that you were just saying before, that actually that PFD point, it is a duty, but it's an ancillary part of the duty and the statutory duty around the 4 questions. not the mainspring, which I think were former Chief Coroner Tommy Teague's words when he said it wasn't a mainspring. And just thinking around Chief Coroner's guidance and training, what kind of training do coroners get on these sorts of issues? Because they're quite difficult to grapple with in terms of, some of this, because it is so subjective. Do you get given sort of training as a coroner, or is there case law? What does it revolve around to sort of say, this is the kind of case you might be dealing with, and this is when it might be appropriate, and this is when actually, it's not appropriate?
Yes, so all judges get judicial training, judicial college. There are days where you go away and you go through this, but it's different every year. So there's annual judicial training. We all go on it, and there will be different themes depending upon what the trainers or those running the training think ought to be the focus. What we've seen recently, and this is what we've seen on the Chief Coroner's website, is a change whereby, going further back, now that we're on our fourth Chief Coroner, we now have all PFDs being made public, and the responses being made public. And then this year we've had the Chief Coroner saying, I'm going to be issuing lists biannually of those who have failed to respond to PFDs. And so this, to my mind, is a strengthening of the PFD system to ensure that when a coroner, in their judicial discretion and their mandatory observations, issues a PFD, they're taken seriously and actioned, so that there is a full circle of this is the concern, this is the action being taken, and there's a public record of that. So I do think that we are looking at a robustness being introduced into the PFD system, some clarity, but also a streamlining so that coroners are consistent across the country in where they should and should not be issuing PFDs. And the tracker that we talked about before has shown some real discrepancies in geographical areas where some coroners at the top of the charts are way ahead in issuing very significant numbers of PFDs, and those at the other end are issuing very few. It might be because of the nature of the inquest or recurrent problems within that particular jurisdiction, and one has to be careful not to utilise statistics to say somebody's doing something wrong, because each jurisdiction will have different things within it. Some jurisdictions will have prisons, some won't, some will be rural, some will be city centre, some will have different types of crime, and so you're going to get local trends, and so there might be very good reasons why, and one hopes that there will be, as to why particular coroners are issuing their prevention of future death reports. But I think the overall messaging that we are seeing with the latest Chief Coroner is a streamlining of PFD reports and a consistency of approach, and that's why we've got all of the Chief Coroner's guidance, the law sheets, and then more recently the bench book.
Yeah, and I think that's in keeping with where the direction of travel as it has been for the last couple of years, which is that there has obviously been concerns around whether PFDs are actually effective at all, whether they're doing what they're there to do and meeting their statutory purpose, and part of that being because there's no compulsion. The coroner doesn't have any powers of compulsion. Yes, you've got this 56-day response period, but if they don't respond, there's no sort of calling them back to court to explain why they've not responded. There's there historically hasn't really been any kind of oversight system as to sort of say, okay, well, what are these PFDs being issued? Which organisations are getting these routinely and not responding, to sort of see what can be done next. And so really one may say, well, what's been the risk if you're an organisation? What's the risk of not responding apart from there just being bad press? But as you say, we've got this this preventable deaths tracker, which is actually the brainchild of Dr. Georgia Richards, and it's done through King's College London, so it's quite independent of the judicial system. But I was having a look at the stats there, and I think they were saying that if you look at what the non-responders list from the Chief Coroner, firstly published on the 1st of January this year, that seemed to suggest there were 37 PFDs that hadn't been responded to in the last kind of calendar year. And those were by a range of organisations, from prisons, councils, universities, hospital trusts, health and social care providers, policing organisations, the Health and Safety Executive, and actually the Ministry of Justice itself was all on that naughty list. But looking at some of the wider statistics, the number of PFDs has been going up. The trend is that they have been going up. Total number of reports, I think, since 2013 is over 5,500 now. And that's going to in excess of 2,000 different recipients. Of those, we know that nearly 40% are currently showing on the preventable deaths tracker as lacking response. 47% have had responses published. So, there's this groundswell, there's this movement towards making it sort of more publicised, the information being more out there. I think we're yet to see whether that's having an impact on actual responses coming through.
Yes, it's very varied. I mean, there are about, on average, 450 PFDs issued a year, and some recipients are very concerned about getting them, and some simply don't care and won't do anything about them. It's paperwork, and they think, well, it doesn't matter whether I do one or not. And also, they can just put a one-liner in going, we're not taking any action, or thank you very much for your PFD. The coroner can do nothing about it. Nobody is going to become knocking on their door saying you failed here. It's a problem. However, the whole point of having it is one of public accountability and transparency. And I have an inquest at the moment where the coroner has turned around the pre-inquest review hearing and said, and by the way, 12 months ago, I issued a PFD on a very similar issue. And so that is going to form part of my thinking here about what was done and what wasn't done. And so that puts us on notice straight away that there is a PFD consideration. So the reality is, if nothing is done when action ought to be taken and another death occurs, or something which is actionable in the civil courts or criminal, then that can well be evidence of people being put on notice that was an issue about which they did nothing, very little, or was insufficient. So the public record becomes something which is quite important and tells the story. And it might well be that the next time round, the coroner says, well, I issued it to you, you didn't do anything. I'm now going to issue it to somebody else in addition to you again. So that somebody who has regulatory oversight, or the governing body, or the parent company, which is a classic, because if you think as to what the Sentencing Council, to put our criminal hats are getting at in terms of the sentencing guidelines, it's to bring it home to the boardroom so that effect comes and changes through the impetus of what's decided at board level. And so if it's those who need to be made aware of it, then you might well get a coroner saying, well, I'll just spread my wings a little bit more and I'll force change and make it more difficult, and then you'll be on more lists of the chief coroner. And if it happens again, and also I think people are much more alive to the fact they can go on the chief coroner's website, search for a particular PFD by topic or name or something like that. And if you're at one end of the country where this has occurred and you want to find out if it's been happening elsewhere, you can start introducing PFDs. And that's what people are going to do, because this is now a very accessible web-based resource.
And I think, thankfully, with the clients that I'm lucky enough to work with, the vast majority of them are very concerned about potentially receiving a PFD, because not only do they, reputationally want to make sure that, that they're addressing concerns, but also they actually fundamentally want to do the right thing. And if they want lessons learned. And I think it was, again, in the Justice Committee debates, that when he was Chief Coroner, Thomas Teague said, actually, they shouldn't necessarily be used as a badge of dishonour, and organisations should welcome them. They should welcome them as to learn from any mistakes, make sure that action is taken to prevent future deaths. That's the responsible thing to do. And I have to say, thankfully, most of the clients that I deal with are always in that camp, so that makes it easier. But looking to now that publicly available resource, that the information that's there. So yes, there's bad press, but it's looking then again perhaps then for that level of accountability. Do you think we're likely to see the non-responders list now, the biannual list being published by the Chief Coroner, as something that will be looked at by regulators and considered by regulators in any of their own investigations, and whether they think, well, okay, over here you've not taken any action, so actually that could be evidence that there's that adds to our investigation I think, against you?
Yeah, I think corporate entities and corporate clients, if they're not responsible in taking it seriously, will find that, you know, the whole pyramid of regulation looks as to any perceived criticisms and things that they could have done better. And so if there's a PFD telling a company that they've got issues and they don't address them, there are going to be questions about that. So I think that there is a heightened understanding of how far a PFD can go. It's not just reputational damage for corporate clients. It's not just that they might not get the next contract or it affects their share price. There can be some really hard-edged regulatory enforcement action taken. But a good corporate client, as soon as they know that they're involved in an inquest, is going to sit down with us and we're going to look at what the learning is, what the gaps are. And anything that we identify has been improved upon is something that we should be telling the coroner about.
Yeah.
It's not to be confused with the ongoing journey of improvement. There is always that, and it shouldn't be a comparison between how it was there and how it is now, unless there's something gone wrong. And it's not to say just because there is an inquest, something has gone wrong. The inquest is to look at what the circumstances are. But those corporate clients who are able to demonstrate the learning are not going to receive a prevention of future death report, because a coroner doesn't need to make one where they're satisfied that sufficient action has been taken so that the concern about future deaths occurring isn't there any longer. And that's an issue in the High Court at the moment, and in due course we're going to get a decision from the Administrative Court, because it's dealing with a very rare set of grounds of appeal, and one includes the suggestion that the coroner was wrong in issuing a letter of concern to a national body as opposed to issuing a prevention of future death report. Now, so far as case law is concerned, we've touched upon Dillon, but it's very rare that these cases come before the court because they don't often get permission. One of the last cases that we had was Mr. Justice Lavender, and it wasn't a classic authority. This was a refusal of permission in Siddiqui in 2017, and his main points were that there's no procedural fairness here. The coroner was obligated to issue a report in the circumstances because they believe that action should be taken. And so when you get a report, you can't judicial review it on the facts. You've got to deal with it by way of the appropriate remedy, which is by way of response. And of course, once a report is issued, the coroner has no power to withdraw it. But what the High Court judge in the case I was involved with is going to have to decide is whether or not the coroner was correct not to issue a prevention of future death report. So in that case, of course, the judge has got to look at the test, what the coroner's views were, and whether or not there was a concern objectively made out which gave rise to an issue about future deaths occurring, which then triggered the mandatory provision of the report, or there was not a concern as to future deaths. It was more of a general concern where a letter was appropriate. And of course, the Chief Coroner's guidance in terms of issuing letters of concern says that they're quite exceptional. So this is going to be a novel point of law and one to watch when we get it, because there just isn't a lot of case law on it whatsoever.
And I mean, is there any record, not as far as I'm aware, of letters of concern that are being issued versus PFDs? Do we have access to that level of information?
We don't, and I don't think the track on this is not a criticism of it at all, because it's a brilliant resource and the website's very, very impressive. And I think coroners are greatly assisted by it, as are practitioners. So it's a fantastic investment in public health and welfare, to my mind. But in terms of letters of concerns, they're not registered, they're not recorded, they're not published. They don't have the same requirements as a PFD report. A recipient isn't required to respond within 56 days. It really is no more than correspondence.
So I think just bearing in mind the fact that obviously there will be these number of letters of concerns out there that we won't necessarily be aware of. Equally, it's probably fair to say, and we should say, there will be a plethora of examples of where PFDs have been issued and organisations have responded, and there has been meaningful change, and probably deaths have been prevented as a result of change. And we don't really hear about that. We hear about the negatives and we hear about what hasn't been done, but there's probably going to be a lot of examples of where action has been taken and they have served their purpose. And we're looking at the topic today of whether PFDs are fit for purpose and they're serving their statutory purpose. So let's look sort of at the positives and look to the sort of the future and where we can expect things to go now. I think it's fair to say that from the conversation we've just been having, it's clear that things have moved on quite a lot in recent years, both in the number of PFDs that are being issued by coroners, in the publicising of those that haven't responded, a new Chief Coroner coming in and giving a lot more guidance in relation to the area, the issue itself. And of course, in November 23, we had the Justice Committee, who launched a new inquiry into the Coroners Service, and that's the service as a whole, not just in relation to PFDs. They heard a lot of evidence throughout last year, including from the former Chief Coroner and the current Chief Coroner, which did include looking at PFDs amongst other things, and we're still awaiting that report. We also had at the end of last year, obviously, the Grenfell Tower inquiry and the report that came out there. And very sadly, what was quite clear was that Sir Martin Morbick found there that had the PFDs in the Lakanal House fire in 2009 been acted upon, there very probably would have been actions been taken, it would have prevented Grenfell Tower itself. That is the context within which I think we need to look at PFDs and the power or the importance of them, and the fact that, they should be fit for purpose in order to avoid tragedies like that happening again.
And that's why we've got Regulation 28, and that's why it was enacted, and it's a relatively low threshold, because if the coroner has concern, and that concern being raised can result in action that would prevent future deaths, then it's something which is very positive. And the Grenfell example that you give is a very significant example where the regime of PFD can be very effective. The variables are the recipients, whether coroners are issuing them and to whom. But also another strength of the system is that it's a public record and it's accessible to everybody, including regulators and anybody that may be affected by a death or have an interest in something that has gone on. So no doubt there will be adverse comment and more for those future interested persons who were on notice that they ought to have done something and failed to do so. But insofar as the PFD regime is there, it seems fit for purpose in the appropriate circumstances where they are issued, so that a coroner can say, I've got a concern. There's not much more a coroner can do because they can't mark the homework when it comes back in by way of response, and they can't make recommendations. So in terms of the law, it remains an ancillary process. It remains whether or not the coroner has concerns. And if anything is more to come through that system, it's going to require some legislative change.
Yeah, and all that remains to be seen.
It does.
So thank you so much for joining me today, David, and that's been fascinating, and I look forward to seeing what comes of your case in the courts on the PFDs versus letters of concern, and we'll read that with interest.
Thank you, Catherine. It's
Thank
been a
you.
pleasure.
Thank you.